First District Court of Appeals now in session. All who have business before this court draw near, give attention, you shall be heard. May God save these United States, the great state of Florida, and this honorable court.
Please be seated. Good morning. Welcome to the First District Court of Appeal. We have two cases on our docket this morning, and we'll take them in the order of the schedule. Our first case is Churchill v. DBI Services et al., 21-3199. Counsel, are you ready to proceed? Proceed when ready.
Thank you, Your Honors. May it please the court. Counselor. Good morning. I'm Mike Weiner from Tampa, Florida, and I have the pleasure of representing the appellant in this case, Ms. Churchill, and I would like to reserve 5 minutes for rebuttal, please.
5 minutes, so noted.
Thank you. Your Honors, Ms. Churchill worked as a restroom attendant for DBI Services, and on November 1st, 2020, she was called in on a day that coincidentally was her day off, and came to work, and her responsibility was to clean restrooms. And as part of that, they had a protocol there with the employer in which the restroom attendants would gather in the area and mix certain chemicals. She was not exactly aware of what the chemicals were that were already in the bucket the day that she got there because they had been left there by a previous employee. And as she started mixing bleach and hand soap along with the other chemicals that were already in the bucket, a sudden explosion, as she described it, that occurred that was similar to what you would envision as a high school volcano science project. And she was engulfed by all these toxic multicolored fumes and vapors that she breathed in, and immediately caused a significant allergic reaction to her eyes, a coughing spell. Make no mistake about it, Your Honor, this event was sudden, it was unexpected, and it immediately resulted in injury to her.
Well, you just said toxic substance, which goes to your fourth issue. First of all, you didn't mention the exposure issue in the reply brief, to my knowledge. Are you abandoning that issue?
No, sir, we're not, and it's a good question. We just felt that it had been adequately addressed in the initial brief, and so we stand on the arguments made in the initial brief. Okay.
So you said toxic substance, so you acknowledge then that this, soup of chemicals was a toxic substance?
Well, obviously, because of not only the medical diagnoses that were made, but because we know at least some of what the substances were. One of it was bleach, industrial bleach. We know bleach is toxic. That's a matter of common sense. Also, we knew that at least one of the other materials, whether it was this honey bowl toilet cleaner or something else, was an industrial cleaner. So, those are, substances which everyone would understand to be harmful to individuals.
So why was it error then for the JCC to apply the exposure requirements, the heightened requirements for exposure to the injury here?
Because of what the nature of the accident was. This was a sudden and an unexpected event where she was engulfed, in what she described again as this sort of scientific high school volcano type of experiment. And there was immediate reaction that she had. Typically in exposure cases, we think of something that's a little more gradual and insidious, right?
Counsel, I agree that is typically what we see, but what is it about the sentence in 440.02 sub 1 that excludes a single exposure?
Well, it doesn't, but by the same token, this accident clearly also meets the legislative definition of an accident, right?
Well,
so
no,
it was a sudden and
because
unexpected event.
The way I read the exposure sentence is that, excuse me, an exposure to toxic substance is not an injury by accident unless it meets the heightened standard. So doesn't that exclude the first sentence that defines accident?
Not necessarily, because again, this was not just an exposure. We more liken the situation of what happened to Ms. Churchill as being as if she was burned, right, by a fire, or if she was burned even by chemicals on her skin. No one would call that an exposure. That would be an actual, physical touching. And because she was physically touched by, the reaction to the chemicals that she dealt with, our position is that categorizes this as an accident, not an exposure.
Don't most exposures involve some sort of touching with some sort of a substance?
Not always. A lot of times, especially when we see most frequently the case law that this court has interpreted has been with regard to mold claims. And these are, invisible things that you never even know that you're coming in contact with that happen quietly and insidiously. Excuse me, I'm sorry?
I'm sorry, you are coming in contact with something.
You are,
Through your
but you
nose,
don't
your
really
mouth.
know it, and there's no real physical contact that you appreciate at the time. The difference here, and I understand that it's a subtle one, but is that she actually came in physical contact with these chemicals. This was something, by all accounts, and the testimony is unrefuted on this point, that this was an actual physical touching of her, just as if she had been physically touched by a caustic acid or been physically touched by a hot flame. And that's what distinguishes this as an actual accident versus an exposure.
The sentence Judge Winokur is referring to has a including but not limited to fungus or mold clause. Does that have any bearing on our interpretation of what exposure to toxic substance means?
Well, obviously the legislature gave two examples of what it intended. I think by virtue of the examples that they provided, what the legislature contemplated was more of these type of, mold, fungus cases and not necessarily chemical cases. If the legislature had intended also to say, we mean, exposure to actual, man-made solvents and chemicals, that would have been listed in Section 440.02, but that wasn't listed in there. And I think we go back to, and I know this wasn't mentioned in the briefs, but I didn't expect this line of questioning. The canon of statutory construction is the inclusion of one thing implies the exclusion of another. And so if we're going to apply that canon of statutory construction to this, we can see that the legislature has only sought to include molds and fungus, those being sort of living toxic organisms as opposed to man-made ones. And I think that provides you with an indication of legislative intent that these exposure to these man-made chemicals was not something that was intended to be included in Section 440.02.
Do you think does the sentence in 440.02 sub 1, does it apply to any single exposure to some type of a toxic substance?
Well, clearly you could have one single exposure to mold, and that would be clearly within the purview of Section 440.02. So I don't think, to be fair and answer your question, you're right. I don't think that the statute necessarily differentiates between one single exposure versus a cumulative set of exposures, which is what we typically see in these types of cases.
Can I jump you to your second issue before we burn through all your time? When was the commencement of payment to require the EC to send the 120-day notice?
Yeah, so the carrier had within the first 14 days had begun the initial payment of compensation benefits. So the statute obviously says upon payment of benefits, and so we know that was within the first 14 days, according to the record evidence that we have, the carrier began paying the claimant's indemnity benefits. And it leads to a very critical point, Judge, that upon means something very important legislatively. There are clear edicts that are contained in this statute that the carrier has to abide by in order to properly deny the case. Otherwise, under Section 440.192 subparagraph 8, they've waived the right to deny compensability. That is a matter of very clear legislative fiat, I would suggest to you. And what the carrier has to do is they have to, upon payment of benefits, and upon, which would have been within the first 10 days, in this case should mean as soon as reasonably practical, right? As soon as the carrier started paying those benefits, they had an obligation under the plain legislative fiat to tell the claimant either we're going to pay your case, we're going to deny your case, or we're going to pay and investigate. And they didn't do that. They just agreed to pay it. As a matter of fact, the adjuster's testimony later on is that, yeah, we accepted the case as compensable, and that continued to be the case. And the carrier really had no new information, according to the adjuster's testimony, that led to its denial, other than the fact apparently somebody changed their mind and said, we don't think it's compensable anymore because you can't meet these heightened requirements under the exposure statute.
Is there a way that we can draw a line consistent with the statute on what when it's too late under the statutory phrase term commencement?
Yeah, well,
Does that make sense?
Upon means something, right? If you were to instruct me, Your Honor, that upon getting back to Tampa, you are to file a notice of supplemental authority, you wouldn't expect me to do it 67 days later, like the carrier did here when they filed their 120-day letter, right? Upon means doing it as soon as reasonably practical under the circumstances. And so that's how I would answer that question. It doesn't mean you have to do it immediately. It's not a fire that needs to be put out that very second, but it needs to be done in a reasonable amount of time and as soon as reasonably practical. And that is not waiting 67 days while this poor woman had no idea that her case was being subject to investigation or later denial. Because what happens in that situation, if carriers don't alert claimants as to what their rights are, which is exactly what the legislature requires that they do, then claimants sleep on their rights. They don't conduct the investigation necessary. Ms. Churchill doesn't hire a lawyer. She doesn't send somebody to go in there and find out what the chemicals were. She doesn't tell her lawyer to, go in there and do a motion for view of the premises to be able to go in and look and see what are the chemicals that are involved here, so that they could then provide them to the experts and have the experts say, yeah, here we go, I've got the exact chemicals that she was exposed to. And now we can testify within a reasonable degree of medical certainty what exactly these chemicals were and what the levels were she was exposed to. She's been denied that because the carrier did not send that letter upon commencement of payment of benefits.
Am I correct that you only need to prevail on issue 2 or issue 4 to have this be compensable? You don't need to win both. If we reverse on either one of those 2 issues, it goes back to the JCC as compensable, and then, whatever benefits, are received from that is a subsequent determination. Correct,
Your Honor. You bring up a very important point, and I'll eat up a little of my rebuttal time because I want to answer it. If you remand on issue 2 or 4, right, on either the fact that this was an accident or the fact that the carrier waived its right to deny compensability of this accident by not perfecting its rights or its responsibilities under the 120-day rule, the claimant has suffered a compensable accident. The carrier still has outs, right? The carrier still, under section 440.1928, still could come back and say, look, there are material facts relevant to the issue of compensability that we could not have discovered within the 120-day period. They would still have that out. And the claimant still always has the burden of major contributing cause, right? So under the Checkers case and the Wooling case that we've cited in our briefs, right, the carrier still has outs in the sense of, they can contest medical necessity of any particular medical benefit. They can still contest whether the work injury remains the major contributing cause of any new treatment that's recommended, and they have all of their indemnity benefits. All the carrier has lost by failing to do what they were supposed to do under the statute is the right to say this accident was not compensable.
Thank you, counsel.
Okay, I'll save the rest of my time for rebuttal. Thank you.
Thank you. They were having technical difficulties with that yesterday, so I'm glad to see that you're able to make that work. You got to start talking, and then the clock will start.
I'm sorry?
You were looking at the clock like you're waiting for it to
Yes, I'm waiting
start.
for a light or something to say, go.
That was me looking at you with a nod, so whenever you're ready.
Okay. Your Honor, I am Jane McGill. I represent the employer carrier in this case. Your Honors, opposing counsel. With regards to the argument that this case does not involve a toxic exposure subject to the clear and convincing evidence standard and creates a presumption, I would like to point out that it is a toxic exposure, and it's a one-time exposure, which this court has addressed in other cases, saying a one-time exposure is all you need to a toxic ingredient, is all you need for it to be a toxic exposure. So the issue here is what's toxic? What is a toxic substance? And there can be, toxicity is a substance depending on 3 factors. It's a chemical structure, the extent to which the substance is absorbed by the body, and the body's ability to detoxify the substance. Interestingly, there are some funguses and some molds that are not considered toxics. They are considered pathogenic or allergic. Toxic is a chemical in a poisonous chemical which only certain fungus and molds create and can cause harm to a person's body.
Well, isn't it undisputed that we were dealing with bleach and hydrochloric acid, both of which would pretty commonly be thought of as toxic substances?
Chlorine bleach is definitely a toxic substance
Okay, so how?
at a certain level.
Sure.
There's a safe level for bleach and chlorine, and then past that safe level, it can be toxic.
And the fact that one of the treating doctors said that she suffered an abrupt injury to her lungs by the exposure to this substance, why is that not enough for it to be an accident under the first sentence in 440.021?
Because the legislature has found that any toxic exposure, even one, takes it outside the realm of an accident, a sudden and unexpected accident as defined in 440.02. The issue, I'm assuming for the legislature, was that with toxic substances, it is more difficult it's so widespread. The toxic substances could be found at home, it could be found at the workplace, it can be found while working in a mall. So it is harder for an employer carrier to determine where was the injured worker when they were exposed to this toxic substance.
That's not really an issue here, though. I mean, she was transported by ambulance to the hospital the same day and was then hospitalized for 5 days thereafter with no pre-existing conditions. So, I mean, it's pretty clear that her exposure to whatever this cloud was caused the injury, right?
That exposure, but the statute says they then have to prove what was the nature of the toxic exposure.
And it was bleach and acid, isn't that enough?
And the initial emergency room physician said it was chlorine. The burden then became for the claimant to prove the amount of chlorine that she was, or bleach.
She has to say that this is like it's been a long time since I've had chemistry, but a 5-mole solution of, whatever chlorine, or can't she just say it's chlorine? I breathed in chlorine. I was fine before. I breathed in chlorine. I was hospitalized for 5 days. Why isn't that enough?
That's not an accident because the plain meaning of the statute says it was a toxic exposure, so it's not an accident.
Is your argument the same if she were to have burned her hands instead of burned her lungs with the substance?
I would say, given the employer carrier followed the rules and they provided treatment, they were not uncertain at the time. They became uncertain later whether the toxic exposures continued to be the need for medically necessary treatment. So the defense was that you have to prove, for the defense it was more not at the time of the exposure, but now and continuing, you have to prove that the exposure to chlorine or bleach 8 weeks ago is still causing these symptoms. And the defense was saying that the claimant did not sustain her burden of proof. She didn't prove that she had been exposed to so much bleach, so much chlorine, that 8 weeks later, it was still causing the major contributing cause of treatment.
Let me get back to, I'm going to follow up on Judge Bilbrey's last question and ask you to, respond to Mr. Weiner's contention that, correct, I apologize if I'm not stating this exactly the way you said it, but that a physical touching is not the same thing as an exposure. I think that's pretty much what Judge Bilbrey was asking about, that if she had injured her hands by maybe sticking them in the solution rather than breathing it in, does exposure not require a physical touching? And if so, is that what happened here?
I think a touching is an exposure because it all depends on how much toxic chemicals did the touching, was it sufficient to cause the symptoms?
So your answer to my earlier question was if she burned her hands in the bleach, that's an exposure case, and she has to prove by clear and convincing evidence what happened. Is that correct?
To me, any doctor, you need medical evidence. All you need is for a doctor to say, yes, that amount of bleach that she touched would cause the burns on her hand. It's clear and convincing. I don't think you would find any doctor who would not say, I am certain within a reasonable degree of medical certainty that that amount of bleach that she touched, a quarter of a cup, extrapolated out, caused the burns on her hands.
Isn't that what we have here?
Litigation in this case, all of the attorneys and all of the doctors were focusing on the combination of chemicals. What were the chemicals in that whole 16-ounce bottle of cleaner? And so they kind of got distracted from just focusing on the chlorine and how much. They knew that there was a quarter of a cup that was added to the solution, and in my research is very clear that they know exactly how much chlorine exposure is safe. Anything above it is
clearly
not safe.
this wasn't a safe exposure here. This wasn't like somebody that had breathed, some mushroom spores like one of our cases, and then maybe suffered an injury months later. This is pretty much instantaneous. She breathes it, she feels bad, she calls her boss, they call an ambulance, she goes to the hospital, and she's hospitalized for 5 days.
Yes, and so it was.
So what more does she have to do to prove that the inhalation of this substance was the MCC of her injury?
She would have to have a medical expert, her IME physician possibly, testify that we know that a quarter of cup of chlorine went into that 16-ounce bottle. We know that when it vaporizes, approximately the amounts of chlorine that are considered safe or not safe is measured in ppms. I have no idea what ppms mean, but a medical expert would know.
I think it's part per million, but
okay.
But isn't it clear here, though, given
So a medical expert would be very easy, I would imagine, and I say that as an attorney going to physicians and saying, recently with the Daubert, I had to explain to doctors over and over again, your training and experience are not enough. You need studies to back up your opinions. With the clear and convincing toxic
I'm following you
standard.
if 3 months after she had breathed in some bleach, she came in and was saying, I was exposed to bleach or, silicon, asbestos, mold, fungus, whatever. I was exposed to a toxic substance X days, months, years ago. That's caused my injury. Whereas here, it was the sudden and unexpected nature of the injury that seems to make it potentially an accident instead of an exposure.
Well, the legislature does not leave open that option. In the plain language of the statute, they do not leave open that option of saying that, well, if you have a sudden an exposure and it causes immediate symptoms, then that's an accident. But if you have a toxic exposure and it doesn't manifest, the toxicity of the substance doesn't manifest until months later, and it would just create more confusion with litigation if you were to say, okay, there's two kinds of toxic exposures. One is an accident pursuant to the definition of 440.02, and another one is a toxic exposure that manifests months later, and then the claimant has a presumption, the employer carrier has a presumption, and the claimant has to prove with clear and convincing evidence. Let's keep it simple, make it fun, and say any toxic exposure needs to be proven with clear and convincing evidence by the claimant, which is really no difference because
Can I ask you, counsel, 440.09, though, talks about occupational, occupational injury where it was occupational disease or repetitive exposure requiring clear and convincing evidence. Clearly, this wasn't a repetitive exposure case, right?
Clearly.
So it's occupational disease, again, seems to me to be, asbestosis, silicosis, something that you get from a repetitive exposure as opposed to a one-time thing. Are you contending that this was an occupational disease that she suffered?
Again, the plain meaning of the statute, the legislature intended to separate out toxic exposures from occupational diseases.
Let me shift gears on you and ask you about the 120-day notice issue. Can you tell us how we should interpret the upon commencement of payment language?
Yes, Your Honor. The claimant's argument that the notification letter is mandatory has already been addressed by the first DCA in 2006 in Checkers v. Whitehoff. In that case, it was actually the employer carrier who argued that we didn't send out a notification letter, therefore we're not subject to the 120-day rule. We can deny anytime we want. And there's some merit to that argument because 440.20 subsection 4 is contradictory. The first three sentences make the 120-day rule appear to be an option. If you're uncertain of your obligation to pay, then you can have 120 days to pay and investigate. But send out a letter notifying the claimant. It's the fourth sentence that the court in Checkers decided that they would enforce because the fourth sentence, which says the 120 days starts at the first date of treatment, makes it mandatory. So the court in Checkers said the notification letter is immaterial, and it implied that uncertainty is immaterial to the start of the 120-day rule. They interpreted the statute in a way that provided the employer carrier with 120 days, mandatory, whether or not they're uncertain or not. As soon as they provide treatment, they have 120 days to deny compensability of the injury, and that's inconsistent. If you are to accept the plain meaning of the statute, you then have to decide whether the statute, I would argue that you have to decide whether the 120-day rule is optional, providing the employer carrier with the option of investigating, which furthers the intent of the workers' compensation law to provide medical benefits and compensation benefits immediately when an injured worker is most in need during the acute phase of an injury, most in need of medical treatment and most in need of finances when they can't work. So it gives them the option. But if you're going to the plain meaning, if you were to accept the plain meaning of, you can't accept the plain meaning of both the first three sentences and the fourth sentence. It's either mandatory, it's either optional. The employer can either avoid paying attorney's fees by utilizing the 120-day rule, or they can just deny from the get-go, just deny, make the claimant prove with medical evidence that there was an injury, there was a compensable accident, medically necessary treatment is needed, he or she is really disabled, and then you have the specter of possibly paying for attorney's fees. And that's the purpose of 440.20. In my opinion, 440.20 subsection 4 is to make sure and to motivate employer carriers to provide quickly and efficiently medically treatment and compensation benefits and give them some time to decide whether really this is a compensable accident and compensable injury.
And Counsel, you're over your time, but can I ask you just briefly on the issue of the deposition of the corporate representative? It seems pretty clear that 440.30 plus the comp rule of procedure allows for depositions like in a civil case, and Civil Rule 1.310 provides for corporate representative depositions, which they tried to take. So at the very least, don't we need to send this back to allow them to take a corporate representative deposition?
Any attorney can take a corporate representative's deposition as long as it's reasonably calculated to lead to admissible evidence. The JCC in this case knew that, and it's in the record, that opposing counsel, the claimant's attorney, had the employer representative's depositions, numerous employer representatives' depositions taken, scheduled, and corporate representatives, would they really know what's in bleach? It was not. And the judge did not immediately deny the taking of corporate representatives' depositions. He said, you take the depositions of all the employer reps that you have scheduled now. We'll revisit this. If you need to take a corporate representative, you still need to take a corporate representative's deposition because you feel they will be able to give you the information. It's reasonably calculated to lead to admissible evidence. We'll revisit it at that time.
Aren't they obligated, the EC obligated to put forth a corporate representative under 1.310? They've got to make somebody available as a corporate representative, and the JCC erred when saying that that rule didn't apply.
If it's reasonably calculated to lead to admissible evidence, yes. I have attorneys who want to take the CEO's deposition of Barnes & Noble up in New York.
Well, sure. I mean, that's the apex doctrine that we put in place and the Supreme Court adopted, so that's what I wasn't asking about. But I think we've burned through plenty of your time unless further questions. Thank you. We appreciate it.
Thank you, Your Honors.
And we'll give the Claimants Counsel an additional 3 minutes since we've asked a number of questions.
Thank you, Your Honors. May it please the Court. I'd like to begin where you left off, Judge Bilbrey, and I think it's an important question. No question the judge of compensation claims erred on the corporate representative deposition. He not only denied the claimant's motion to compel, he granted the employer carrier's motion for protective order. The claimant was 100% foreclosed from the ability to take the deposition of a corporate representative. The import of that is those statements and that testimony of that designated corporate representative binds the corporation. There's no way the judge of compensation claims could have known what was reasonably calculated to lead to admissible evidence from a witness who he had no idea what the witness would say or what the witness would reveal. That involves complete divinity of the unknown, a power which no judge or no human has. Because we know that it's error, we also know that under the Special versus Boca West case, that the employer carrier, as the beneficiary of that error, had the burden to prove in its briefs that there was no reasonable manner in which that error could have contributed to the verdict. They didn't even address that point. And so I would humbly submit to Your Honors that is fertile ground for reversal on that point alone. It is absolutely clear the judge made error. And if nothing else, I think judges of compensation claims need to understand that these rules do apply, right? The corporate representative rules apply. Section 440.30 says it does. The 60Q rules say it does. And your Latour decision from about 9 years ago also says that it does. So we have reversible error right there. Let's go to the other point that was made, and questions were asked about this, about the uncertainty. We heard counsel for the employer carrier say that the employer became uncertainty. I would humbly suggest to you there's absolutely no record evidence of anything new that developed that led to the carrier becoming uncertain. Instead, as a matter of fact, the adjuster's testimony confirmed that. If you go back, and we've cited it both in the initial and the reply brief, the adjuster's testimony confirmed that when they denied the case, they had no new evidence. Now, when they denied the case, what did they say? They say, you can't meet this onerous exposure burden, something that presumably the employer carrier should have known since day one, right? If their position was all along that this was an exposure, that was not something that just randomly came about. They knew from the very beginning what the nature of the accident was, and we, again, maintain steadfast this was an accident, not an exposure, but the carrier knew from the very beginning what this was.
What does the Checkers restaurant case or en banc case from 15-plus years ago now mean? How does that impact this?
Yeah, I simply do not read Checkers the same way that counsel for the appellees read Checkers. I read Checkers to stand for the proposition that if the carrier waives the right to deny compensability, that they still have the right to come back later on and contest issues of medical necessity, major contributing cause. That's what Checkers stands for. Checkers does not deal with the mandatory nature of the 120-day letter. I think Bynum sets the stage for the arguments that we've made here. We've argued the Bynum case in our brief. The appellees have too. And the Bynum case, which has been relied on numerous times by this court, says there are three things that you need to do when you're the carrier and you start commencement of payment of benefits. You either accept the case, you deny the case, or you send a 120-day letter. Those are your three options. And those three options, let's put some context around this here, because this is supposed to be a system that is designed to operate quickly and efficiently. We have trials that have to be had within 210 days, obviously, and the complete legislative intent behind Chapter 440 is that we have an efficient system that provides benefits to injured workers efficiently. So we need carriers to make quick decisions about what they're going to do. And the unambiguous, plain language of the statute is that if you are going to make the decision, if you're going to accept it, then you accept it. That's fine. Even if you accept the case, you can still, like I mentioned earlier, you have your outs later on that you can say under 440.192, there were facts about the compensability of the case that we could not have reasonably have discovered within 120 days. And number two, carriers still have an out to say the treatment's not medically necessary. It's still not causally related as it pertains to individual treatment. But if you accept the case, then the case has been accepted as compensable, and that's what happened here. And if you're uncertain about your obligations, which I would submit to you probably was the case here, the carrier, or at least they tried to play Monday morning quarterback and say that we were uncertain, then you have to send a 120-day letter. And the reason is...
Am I understanding you correctly, your previous answer, that the upon commencement is a fluid timeline?
No. It is to be done as soon as the carrier makes its first payment of benefits. That is when the carrier has to send the 120-day letter. It is not something to be sort of invoked later on down the line. And then I would submit to you the reasoning is so that you can avoid the exact problems that happen in this case, right? If the carrier waits 67 days before sending its investigation letter to the claimant, then what ability does the claimant have to go back into that janitor's closet and put all these chemicals together and say, here's what it was that I was exposed to?
So does the letter need to issue literally the same day or the same moment as the check?
I'll go back and I'll say as soon as reasonably practical thereafter.
And so that's my point. So there's some fluid.
Some fluidity, yeah. I mean, it doesn't. I'm not trying to say that it would be a hard line. It has to be done the same day. But I think reasonable law is contextual, right? But reasonable under the circumstances. Waiting 67 days is not reasonable by anyone's measure, right? That is not congruent with a legislative edict that tells you must do this upon commencement, right? Because upon means something, and it means the legislature wants you to do this, I would say, as close to immediately as possible. And, based on the number of errors that we've identified, we feel, and including the first point, which we never even got to, but we're not certainly abandoning that, the judge should not have dismissed the attorney's fee claim with prejudice, but also the judge's error in terms of not allowing a corporate representative deposition, the judge's error in categorizing this as an exposure case when in fact it was a physically touching accident case, and I think most importantly, the judge's failure to properly rule on the 120-day rule and find that the carrier waived the right to deny compensability because it did not send a letter, or waived the right to deny compensability because it accepted compensability. All those require that Your Honors reverse this case and remand it with instructions to the judge consistent with what we've asked for in our briefs.
Thank you, counsel.
Thank you, Your Honor.
Thank you both for the argument. We'll allow you to reshuffle the courtroom here and bring up our second case.
Thank you, Your Honors.
Thank you. Our second case on the docket today is Sylvia Matthews as personal representative of the estate of David Locke versus Tri-County Gas Services. This is 22-602. Counsel, are you ready to proceed?
Yes, Your Honor.
Proceed when ready, then.
Good morning, Your Honors. May it please the Court. I'm Lindsay Walton, and I represent Sylvia Matthews as the personal representative of the estate of David Locke. This case is an appeal from a summary judgment entered in a premises liability action. The action arose from a fall on Tri-County Gas Services property.
And Ms. Lawton, before we get too far into it, would you like to reserve any time for rebuttal?
Yes, Your Honor, thank you. I would like to reserve 5 minutes.
5 minutes, thank you.
David Locke fell on the property of Tri-County Gas Service, and that was the cause of this case. And we are here today because the trial court granted summary judgment for Tri-County Gas Service over the estate's argument that summary judgment would be premature because discovery was not closed and investigation was ongoing. Entry of summary judgment when the record is incomplete is error as a matter of law. In this case, not only was it clear from the record that the record was incomplete, but there was an outstanding motion to compel Tri-County to provide the most basic of discovery requests, and for its president to enter admissions about a surveillance video that he had viewed, according to information the estate's attorney had received, but which has since gone missing. The estate asked this court to reverse and remand so that discovery can continue, and this case can ultimately be decided based on a true adjudication of the merits. Rule 1.510A requires a party moving for summary judgment to show that there is no genuine dispute as to any material fact. The moving party cannot do that when the record is patently incomplete, like it was here. When discovery is ongoing and
How
investigation...
are we to decide that? How's the court to decide whether or not the record is complete?
When you have an objection like we have here from the non-moving party that explains the discovery efforts that have been undertaken and the investigation efforts that have been undertaken, that shows the record is incomplete.
But how does the timing, though, of the discovery fit into this? I mean, some of the objections were lodged apparently 8 months before the summary judgment hearing. The trial court didn't specifically say to the plaintiff's counsel, no, you've taken too long, as you know, you hadn't been diligent in pursuing this. But by going forward, isn't with the summary judgment, isn't that kind of implied that the court's thinking this is enough time, we've given you enough time to try to flesh out any material facts, so now we're going to go forward with summary judgment?
No, Your Honor, I don't think you can read into the record an implicit overruling of the request for more time. In this case, there was never a discovery deadline set. There was never any express ruling by the trial court on the motion to compel, or even on the only response that we had to the summary judgment motion, which is that it was premature.
Counsel, I don't think it's really implied. I mean, you made the same points about the necessity of discovery in a motion to reconsider the order granting summary judgment. So it's not just simply an implication, that they rejected your discovery arguments. You made them explicitly, and it was rejected. Isn't that the case?
It is the case, Your Honor, that we made the objection explicitly. There is no explicit ruling by the trial court. The summary judgment rule requires the trial court to state its reasons for granting summary judgment. In this case, the only reasons were that the estate didn't have the evidence. There was no statement by the trial court in the summary judgment order or in the summary denial of the motion for reconsideration about the arguments that we made concerning the premature ruling.
So how then was the court wrong in saying that there was no way that you could have provided legal evidence that would have supported liability?
Well, the trial court should not have jumped to that question when we had an outstanding objection about the way discovery had been conducted in this case, and when we had an outstanding motion to compel. And that is supported by case law of the federal courts under the federal summary judgment standard, particularly the Snook case that I relied on in the initial brief and the reply. Also supported by cases from Florida courts, particularly the Abate case cited in the briefing. When there's an outstanding motion to compel, the trial court can't just jump to the merits. And that is a matter of fairness, which is something that the summary judgment rule is concerned with and that the Florida Supreme Court was concerned with when it adopted the new summary judgment rule. In the opinion adopting that rule, the court said that fairness and efficiency are considerations that are appropriate for this. The court said that the summary judgment rule should be interpreted consistently with the federal summary judgment standard, and that language is even incorporated into our rule. The Celotex case says you can't decide summary judgment when the record is inadequate. And here, the record was patently inadequate, and the reason it was inadequate was the plaintiff died early in the case, and that severely complicates an ability to prove a case. What you do when the plaintiff dies is you look for other evidence, and the starting point is, are there any other witnesses? Is there any video? The plaintiff here tried to get that information, and I'd like to read you the response that they got. The plaintiff said, "I want the names, addresses, and telephone numbers of the employees who were working on the date of the incident at the subject premises." The response by Tri-County was, "This request is overly broad, not limited in time and scope, and not reasonably calculated to lead to the discovery of admissible evidence. And it improperly solicits the confidential and protected medical and financial information of non-parties." That response is frivolous on its face. This information that was requested was just basic information that any plaintiff is entitled to have in a case. There was no excuse for this response, and a ruling on summary judgment that rewards this response is not consistent with what summary judgment is supposed to do.
To what extent is there a due diligence question here about the plaintiff's due diligence in pursuing discovery?
I understand, Your Honor, that the opposing side has argued that we should have done something else, should have filed a motion to compel sooner. You can always say that somebody could have done more in hindsight. But the fact is there was no blown deadline. There's no deadline for filing a motion to compel. We shouldn't have had to file a motion to compel for this basic information.
What was that response? And I agree with you. The objection on financial and medical information when that wasn't even requested is a frivolous objection and shouldn't have been made. But was that response 8 months before the summary judgment hearing? Is that correct?
It was, Your Honor. In the meantime, the plaintiff's counsel had to scramble around following the death of the plaintiff. An estate had to be created, an estate had to be substituted. The record shows that in July, this response that we're talking about came in to the discovery request came in January and February was when they responded to the request for production and the responses to the interrogatories. So that happened in January, February. Meanwhile, the plaintiff had died. His family's dealing with that, scrambling around to create an estate. An estate has to be created, substituted as a party. We get to July, a new trial counsel is substituted in for the plaintiff. And shortly after that happened, the summary judgment motion came in. So, I mean, it may seem like a lot of time, when you're just looking at the dates on the paper, but there were a lot of things happening. There was no argument below that there was a lack of due diligence. And again, there were no deadlines blown. If the defendant was in a hurry to have this case resolved, then the defendant could have asked for a case management conference and a scheduling order. The defendant chose not to do that.
Is a finding of due diligence or lack thereof required before the trial court can proceed when there's outstanding discovery?
Well, the trial court is required to rule on the argument that this summary judgment motion is premature and to rule on a motion to compel. Whatever the reason the trial court might give for denying that kind of motion or rejecting that kind of argument. I'm not sure if they're limited, but certainly due diligence or lack of due diligence would be one way that, one reason the trial court could give for denying a motion, well, for proceeding to summary judgment over the argument that it's premature. But in this case, the trial court didn't offer that any explanation. The trial court really just entered a proposed order provided by the defendant that in that order didn't even address this issue.
Is it your contention that the representations by plaintiff's counsel at the summary judgment hearing were sufficient to comply with the new 1.510D, the when facts are unavailable to non-movement, which says if a non-movement shows by affidavit or declaration it can't present essential facts, the court may defer ruling and do some other things. Are you saying that the counsel's statements in court at the hearing sufficed for that?
I'm not just the statements that were made in court, Your Honor, but also the written document filed before court on October 14th, signed by counsel, that explained the reasons that they didn't have the facts, and the reasons were that discovery wasn't closed, that Tri-County had given this obstructionist response to discovery for basic information. I submit to you that the written document filed on October 14th qualifies as a declaration. The rule doesn't define what a declaration is. It is signed by an attorney as an officer of the court with ethical obligations to tell the truth. And that argument was supplemented at the hearing on summary judgment, and that satisfies the rule. In addition, Your Honor, I would argue that this rule says, if a non-movement makes this kind of affidavit or declaration, the court may do a number of things, but it doesn't say that this is the only way to postpone a decision on summary judgment. The trial court generally is supposed to, oversee the proceedings, and in any kind of procedure that's pending before the trial court, there can be a motion to continue. The summary judgment rule doesn't say that you can't have a motion to continue or any argument outside of 1.510D. But again, Your Honor, I do argue that what happened here satisfies the declaration requirement. And again, the federal case law on this point, in the case of Snook, supports that point. Also, Your Honor, the appellee, Tri-County, never argued that the estate should have submitted anything better to improve on the declaration that the attorney made. That could have easily been fixed had that kind of objection been raised. Instead of raising any kind of an argument in response to the premature point, Tri-County just proceeded as though that argument had not been made, submitted a proposed order on the merits, and the trial court entered that. If there are no further questions, I will reserve the remainder of my time for rebuttal.
Thank you.
Good morning, Your Honors. May it please the court, counsel. My name is Brent Palmer. I'm here today on behalf of Tri-County Gas Service, the appellee. The trial court summary judgment in favor of appellee must be affirmed. Failing to do so will render the time frame set forth in the summary judgment rule meaningless, will render the rule itself useless, and will encourage civil litigants to delay cases. In this case, as a threshold matter, what's important is there's no dispute that the summary judgment ruling was proper insofar as there was no record evidence that would create a material issue, a genuine material issue of fact. This appeal solely concerns, number one, whether relief was properly sought under subsection D, and whether the appellant was entitled to that relief under subsection D. Appellant fails on both counts. In reaching these conclusions, we must remember the purpose of 1.510, the motion for summary judgment. It's to secure a just and speedy conclusion to civil litigation. Now, gentlemen, this morning and in the briefs, we've seen it repeated time and time again, incorrectly, each and every time. There was no discovery deadline. Your Honors, 1.510 imposes a discovery deadline. As soon as that motion for summary judgment was filed, appellant had notice. As soon as that notice of hearing was filed, there was a deadline, and that was 20 days before that hearing. Now, in this case, Your Honor, not only was there more than sufficient notice and more than sufficient time and opportunity, but there absolutely was zero prejudice as a result of the discovery responses. Subsection C1B permits summary judgment to be based upon a showing that an adverse party cannot produce admissible evidence to support a fact. In this premises liability case, they couldn't identify what the alleged dangerous condition was. They couldn't identify where it was. They could not prove causation.
Well, couldn't some of that be, though, that you wouldn't disclose any of the employees that were present? I mean, they could have deposed somebody with knowledge and said, well, yeah, you know, a sinkhole opened up, or, you know, a fellow employee came out and purposely tripped the guy or something like that.
Your Honor, thank you very much for bringing that up, because what was misrepresented to you is that they asked for the names of the employees in that discovery request that counsel just read. That was a request for production, Your Honor. It was a request for production. The only lists that Tri-County Gas had was employee files, the personnel files. We know you're not entitled to wholesale disclosure of personnel files. That was the purpose of that objection. Had counsel reached out and said, Mr. Palmer, because I was trial counsel, myself and Mr. Waldron, we want to take these depositions. And in fact, it's in the brief, it's in the record. While I didn't list the employees, I said they may be contacted through counsel. You want depots? Come ask for them. And we gave them the name of James Manuel, the president, and said he is the one with the most knowledge about the maintenance and the condition of the premises. We told them, you only need one deposition, and that was disclosed in February of 2021. You can't just pick and choose this discovery response and focus on it. We told them there was no witness to this accident. And what's important
So are they to just take your word for that then, that there's no witnesses? I mean, were you really confused that they were, about what they were asking for?
Can you be more specific, Your Honor?
Were you unclear that they were trying to get the names of the employees that were present and working that day?
They didn't ask, they asked for all employees. The request for production that she read, it did ask for the personnel files for the folks on that day. The interrogatory said all employees for Tri-County Gas. And what's important here, Your Honor, is this is a self-service car wash that is located on Tri-County Gas's property. This isn't as if, you know, some of the cases, one of the cases that was cited in the brief was a Publix case, where the plaintiff in that case asked for the identity of the bag boys in the area where the accident happened at the time of the fall that saw it. In this case, what they asked for was anyone who may have been there that day. Now, we disclosed in a sworn verified interrogatory that was provided to them, none of them were there. None of them saw it. This is a gas service. They load up the gas trucks and they deliver it. The self-service car wash is located on the property. And we're talking like the difference between where visitors park and where employees park for this courthouse. We're talking, I believe it's an acre or more than an acre. Nevertheless, the point is, if they had questions and they had a sworn interrogatory response in which they said, there's one person who has the most knowledge about all of this. They never took that deposition, Your Honor. Never even requested that deposition, Your Honor. We've got to presume that when those interrogatory responses, those requests for production responses were received by appellant's trial counsel, he read them, he looked at them, or maybe not. Maybe not. That's why we're here, Your Honor. If I had came here this morning and I said, shucks, I think there's something we need to add to the record. I think there's something that I didn't argue. You'd look at me straight in the eye and you say, well, Mr. Palmer, there's a procedure for that. And there's a procedure for that in the trial court, where under 1.510D, it says you file a motion to continue. You file a motion to continue. They never even did that. He never filed a motion. If you look at the plaintiff's response, appellant's response to the motion for summary judgment, it doesn't reference 1.510D anywhere. He simply says that we have ongoing discovery. The night before, I was obligated to file my response to Tri-County's motion for summary judgment. I finally recognized I haven't done anything for 7 months. That's what's happened here. And then he says, I want to take a deposition. We heard about it in the last case, Monday morning quarterback. Now, in front of this court, we have a Monday morning quarterback who's saying there's things that could have been done. And what's important, most important, is they're not entitled to relief under 1.510D because they were not diligent. Not only were they not diligent in following up on the discovery, should they have had an objection? Should they have said, Mr. Palmer, we'd like to take these depots when I already offered contact them through counsel. We'll set it up. In the interrogatory
the lack
response.
of diligence that you're saying, is that something that we can determine, or did the trial court?
The trial court already determined it, Your Honor.
But did he specifically, he obviously granted summary judgment.
Yes.
So there's some implicit determination of it, but he's never had a ruling that I'm aware of that said, you've been dilatory in moving this forward. You've had plenty of time for discovery. We're going forward. You hadn't been diligent, so summary judgment.
Yes, Your Honor. It's implicit and it is a kindness from the trial court to not put that in writing. What happened was we filed the motion. The response was insufficient. They filed a motion for reconsideration where they raised that issue. And then the trial court said, I've reviewed this. I'm not convinced. Here's your summary judgment order, granting the motion for summary judgment, because they never objected to the discovery responses over 7 months. They did not propound any additional discovery. Plaintiff's discovery response, plaintiff never responded to my discovery. I issued in December of 2020. Never. They want to talk about objection. At least they got responses. Never responded, never even acknowledged them. I subpoenaed EMS records. They want to talk about 911 calls. I went and got the records. Gentlemen, never even filed a request for copies. It's in the record. They never requested Mr. Manuel's deposition. Never requested a corporate representative deposition. Never reached out to say, I want to take these employee depositions. Never deposed the EMTs. They never requested the surveillance footage. They never sought a records custodian deposition for these 911 calls, which, by the way, we all know is confidential. The identity of 911 callers is confidential as a matter of law under Florida statute. Never filed or presented any evidence that a public records request was even made. Instead, gentlemen, this is what they did. On May 6, 2021, after the personal representative appeared in the case, they filed a proposal for settlement. They told Tri-County Gas Service, we all have enough information, and we filed, and this is what you should settle for. You know enough, and we know enough about this case. On April 6, 2021, there is a notice of service, a proposal for settlement in the record. They didn't need depositions. They didn't need more complete discovery. They said, as a matter of good faith, as an attorney sworn to tell the truth in these signed documents, he said, I know enough about this case to make a good faith estimate as to the value of this case. In June, we filed the motion for summary judgment, placed them on notice. Shortly thereafter, it was set for hearing. It wasn't set for hearing until November 7, 2021. No, November 3rd, 2021. I apologize, Your Honor. At that time, there was a deadline, just like there is all over the Florida Rules of Civil Procedure. A deadline. We hear that there was no scheduling order. There was a scheduling order established by the Florida Supreme Court when they enacted 1.510. That's a scheduling order, and that is as effective as any case management order that is entered by a trial judge. We also heard that it's defense counsel's fault that they didn't tell appellant's counsel they needed to do something. It's the trial court's fault because the trial court did inquire. But gentlemen, Florida law puts that burden on appellant. In this case, what's also important is 1.510D says you got to show there's facts you can't get. There's no facts they couldn't get.
Would you agree that an attorney's representation suffices as a declaration under D?
I would agree that a proposal for settlement is a representation from an attorney, and I would agree that the attorney's representation that he has not done certain activities is a certification, and I would agree that the statement that was provided in this case was woefully insufficient because they never represented what facts they could not discover. Your Honor, they could have set aside an inspection. In fact, this isn't even a controlled piece of property. They could have entered this property, taken photographs, talked to other customers. They didn't do it, Your Honor. And respectfully, because they didn't do it, the summary judgment was proper and must be affirmed. Thank you, gentlemen.
Thank you, counsel.
Counsel says that I have misrepresented the record regarding the discovery requests and responses. I have not. I asked for you to look at page 47 of the record. That is the page that I read earlier. It was in response to, it was the response to the request for production, where we did not ask for a personnel file. We asked for names, addresses, and phone numbers of the people, the employees who were on the premises at the time. The response from Tri-County was not that there were no employees. The response was, as what I read before, and additionally, that the unnamed employees could be contacted through counsel. That was insufficient. We were entitled to know who those employees were, and partly because those employees may not have even been working there anymore, in which case we would not have been required to go through counsel to reach them. Additionally, page 111 of the record is the unsworn interrogatory response that came out before the summary judgment motion, and that shows that the interrogatories also requested the name, last known address, and employer of each and every employee employed by defendant and working at said location on the date of the incident as alleged in the complaint. The response here to the interrogatory is that they don't say this business about financial and medical information, but they say it is not properly limited as to scope and not reasonably calculated to lead to the discovery of admissible evidence. These interrogatories were not sworn. In fact, they were not sworn until after the response to the summary judgment came in, and they were required to be sworn by the rules. Counsel says that the rule, that 1.510D requires a motion. It does not. It requires a declaration. We filed a declaration. Under the definition, one of the definitions of declaration in Black's Law Dictionary is an unsworn statement made by someone having knowledge of facts relating to an event in dispute. There's also another definition that requires it to be said under penalty of perjury. We didn't have that here, but again, the rule doesn't define declaration. The Snook case from the 11th Circuit says that an affidavit is not required. And counsel says that if you follow Snook, that is going to render summary judgment meaningless. Well, that's not true. Summary judgment is very meaningful in the 11th Circuit Court of Appeals jurisdiction in the federal courts. There was no questioning about due diligence below. A lot of the facts that counsel is suggesting might suggest due diligence are not in the record. We don't know what efforts were being made behind the scenes or what date the 911 call was requested. We know it was requested. Counsel says that we all know that that call is confidential. I don't know that. And that argument hasn't been made, and no authority has been cited in the briefs for that suggestion. Your Honor,
If you want to wrap up, you're out of time.
yes, I would request that you reverse and remand for further proceedings so that this case can be decided on the merits and for all the reasons argued today and in the briefs. Thank you.
Thank you, counsel. Thank you both for the argument. With that, we have no further business before the court, so we are adjourned.
All right.